Welcome to our second lecture covering the topic of disability discrimination. In our first lecture, we did an introduction to the topic of disability discrimination, and we discussed how the prima facie case is made by the plaintiff in such cases. We also talked about the definition for the term disability. In the rest of this lecture, we'll go through and talk about additional terms that are important in terms of vocabulary. And so let's get started. So our next term up is major life activity. As you'll see in this section, vocabulary is really essential, and terms don't necessarily mean what they might mean in everyday conversation. So please note these terms so that you'll be familiar with them when it comes time for tests. And you can see we have our term right here, substantially limited. This term used to mean something a little bit different under the law. And what Congress did was in 2008, changed how this term was applied going forward. So it is important when you're looking at cases that relate to the term substantially limited, that the cases you're looking at happen after 2008, so that you can make sure you have something that is going to be current law. So here's a definition that you'd want to put in Quizlet or whatever your tool is for learning vocabulary. So substantially limited occurs when an individual does not need to have, an individual does not need to have an impairment that prevents or severely or significantly restricts a major life activity to be considered substantially limited. Nor does the impairment need to last for a set period of time, although we'll see going forward that 6 months is kind of a minimum. In addition, the limitations that causes the the impairments that cause the substantial limitation doesn't have to be one, so you can do combinations. In our last lecture, we talked about a situation where Bob had a mild intellectual impairment paired with a mild case of ADHD. And those two together, in combination, substantially limited his major life activity. I can't remember which one it was, but and so you can have these in combination. And again, the goal for substantially limited is to have a broad coverage. So there shouldn't be, the intention is for this to cover relatively more people. Remember in our last lecture, we talked about how the way the U.S. Supreme Court interpreted substantially limited was going to restrict the number of people who met the definition for applicability of the statute. But Congress said, no, we want it to be bigger. We want it to include a lot more people. Now, obviously, there's still people outside, people who don't have a substantial limitation, but it's going to include more people than the original case law indicated it would include. So, of course, our second term is major life activity, and here's a definition. You can see I put it in quotes because it's from the statute. Functions such as caring for oneself, performing manual tasks, walking, seeing, hearing, speaking, breathing, learning, and working. This is not an exhaustive list. These are just some examples, and we'll see, in fact, some more going forward. We'll also see that the concept of major life activity also includes the operation of a major bodily function. This was also an addition that happened in 2008. You don't need to know when it was added, you just need to know that it applies now. This change did not significantly increase the number of things covered because most major bodily functions also count as a major life activity. And again, the definition here of major life activity is not to limit it significantly, but to have a broad coverage. And again, we've already talked about the terms impairment, and we've talked about the fact that temporary impairments, ones that are less than 6 months, are not going to be covered. I don't have it here, but just keep in mind that pregnancy is not covered here. We have coverage for pregnancy under the Pregnancy Discrimination Act, which was an amendment to Title VII, but it is not covered under the Americans with Disabilities Act. You'll also find some applicability to pregnancy in the Family and Medical Leave Act, and we'll talk more about how that works in another module. So we need to have individualized evaluation or assessment. You will see throughout this module that we constantly are talking about individualized evaluation or individualized assessment. This is an essential concept, and it will come up again and again and again. So you can't just take a diagnosis and say, oh, that's a disability. I mean, there are a few that you can say categorically that has to be a disability, but you are supposed to do this individualized analysis. You'll also see when we're talking about reasonable accommodations, we need to do an individual analysis. When we're talking about undue hardship, we need to do an individual analysis. So it's going to not be a cookie cutter situation. Let's look at the scenario. So Mary experiences extensive verbal abuse and teasing because she stutters. So the question might be, does stuttering count as a disability? Mary wants to file a complaint of workplace harassment under the ADA. Mary can bring a claim of workplace harassment under the ADA if she can show that her speech impediment and stuttering affect a major life activity. And the ones that Mary might want to think about are speaking or communicating, or both, really. Or if her colleagues consider her or regard her as if she were disabled. Again, this assumes that the circuit that we're in treats workplace harassment as a claim. So again, we would need to do that individualized harassment. If the speech impediment is sufficiently minor that it doesn't count as something that substantially limits Mary, then it's not going to meet that definition. But certainly stuttering can be severe enough that it does result in a finding of substantial limitations. The reality is, when we have individualized evaluations, and of course we do for all these situations, is that the employer is kind of left guessing what a judge and a jury would do. And so most employers err on the side of inclusion. Now, would somebody who stutters infrequently, or when they stutter it's easily resolved, would that person meet the definition? No. But if you have somebody near the line, most employers are going to say, let's treat it as if it were a disability, even if it isn't, just because that's a safer legal course to take. So usually employers don't want to be in the gray area where they're not sure if it's a disability, but they're going to assume it's not. That's not a safe place for the employer to be. So again, here's that list I was telling you about, and you can see it's significantly longer than the list I had over here. And this list is not complete. So I had some examples here, but this is a more complete list. And again, this is not, we'll see major bodily functions on the next slide, but you can see here that thinking and working are on this list, and also learning. In addition, you will see that, actually we don't have reproducing on this. I guess they're counting that as a major bodily function. We'll talk more about working in a couple minutes, but a lot of times the thinking ones will be, and there are also oftentimes the learning ones, will be learning differences. I'm just going to do an LD here, and these could be dyslexia, dysgraphia, other learning differences that cause people to need to learn in a different way, or need to learn, or it takes them longer to learn particular material. And we'll talk more about working in a few minutes. So here are these various functions, and you can see reproductive functions. As we talked about before, jobs aren't going to require a person to be reproductive or to be able to reproduce, but that is certainly a major bodily function, and that would be covered. So a person, for example, who needed time off for surgery to address an infertility problem would be covered as a disabled person. And you can see for basically any bodily function you can think of is going to be covered here. Let's talk about qualifications. So of course, in order for a person to be covered under the ADA, they have to be a qualified individual. This is the same requirement that we saw in Title VII and the Age Discrimination in Employment Act. If a person isn't qualified for a job, the fact that he or she didn't get the job isn't based upon a discriminatory reason, obviously. And so we always have to, first of all, look for the person, whether the person is qualified or not. And we actually look at this before we even go through and see if the person is disabled, because if the person is not qualified for the job, it doesn't really matter whether they're disabled or not. So this is kind of the first question. Is the person qualified? The second question is the person disabled? And then, of course, we would go through and try to sort. Once the answers to both these questions are yes, that's when we go and do the reasonable accommodation analysis. Again, I'm going to be honest with you. These are relatively rarely you're going to come up with no. So most of your activity in this practice area is going to be here, deciding what the essential functions are that need to be reasonably accommodated and how you're going to go about doing it. But these are threshold questions. The employer has a good amount of judgment about deciding the essential functions of a job. Let's pause for a second and say, what needs to be reasonably accommodated? Only the essential functions of a job have to be reasonably accommodated. So if you think about a job, let me clear this off for a second. So imagine that a job involves, this is the universe of things that you do on the job. And let's say you're a secretary and you spend a lot of your time typing, and you spend a fair amount of your time filing, and you spend a fair amount of time taking dictation, and you also spend a fair amount of time scheduling appointments. You end up filling out a fair number of forms, expense reports, things like that for your boss. And you also sit in and take notes on many of your boss's meetings. But there are some very small tasks that you also do. They take up, 3-4% of your time. They're not significant investments. These wouldn't be essential functions of the job. For example, when you are the backup receptionist, when both of the other receptionists are unavailable. That doesn't happen regularly. Maybe you spend 15 minutes a week being a receptionist, really small part of your time. Well, that wouldn't be an essential function of this job. Somebody else can cover during that time, especially if there's another secretary that's available that would be able to do it, or some other office person. Another task might be making coffee. You oftentimes will make, or not oftentimes, but maybe 2-3 times a week, you make coffee for a conference or a meeting that's going on. That very likely, maybe it takes you a total of 15 minutes or 20 minutes for a week. Well, that could be delegated maybe to the receptionist, and so he or she could take on that responsibility. And you can see we might go through and find several of these other functions. So a good rule of thumb is how much of the time of the job is involved in it. And if the person's doing it only an hour or less a week, it's probably not going to be an essential function of the job. Now, that's not always going to be the case, because there could be essential functions that are really why the job exists but are done infrequently. I knew someone once who worked for the who was in the Army, and the nature of his job was he needed to be available to do something during his scheduled work day. He rarely had to do it, but gosh, that was the reason his job existed. And so he might go a week and not have to do that even once. But that was the reason that he was stationed in a particular location. So certainly doing that task, even though it was rare, was truly the essential function that he was looking for. So essential functions have to be reasonably accommodated. So the typing, the filing, the taking dictation would need to be reasonably accommodated. But the non-essential functions don't have to be reasonably accommodated because they can be shifted to another person. So again, the fact that, let's say, I am unable to be the receptionist, and that's not an essential function to me in my role as a secretary. And it could be for certain secretaries, but in the scenario that I presented before, it wasn't an essential function. It's not necessary to reasonably accommodate me in that. Just make it go away. Just transfer it to somebody else. Now, if you're going to insist that I do it, hey, it is an essential function, you have to do this, then that's going to have to be reasonably accommodated. But many times the easier course of action is going to be transfer that to somebody else who can more easily do the function. So Again, if it's non-essential, you can remove it and put it with somebody else. But if it's essential, you're going to have to figure out a way to reasonably accommodate it, you meaning the employer. So deciding whether something is essential or not is usually going to fall on the employer. Courts usually don't do a lot of second guessing of the employer's judgment about this. The idea is the employer is the expert about how it wants to accomplish the work that it needs to perform and how it divides up the pie, because it knows everybody's skills and has its own hierarchy and its own way of doing things. And so it's pretty rare that a court is going to step in and say, I disagree with you. I don't think that's an essential skill. But of course, the employer has to have made that judgment somehow. It needs to be, a thoughtful approach. And usually this is going to be in a job description. Oftentimes these are called position descriptions. I use both terms here just so you can see them. And a lot of times they will be called PDs. It stands obviously for position descriptions. And these are documents that are produced without reference to a particular person. So for example, when I was at JCPenney, we had a position description for customer service associates. Those are the clerks that help you when you are purchasing items in the department store. Now, obviously, we had tens of thousands of people in that particular role. So the position description wasn't thinking about Mary's strengths or Bob's strengths or Mary's weaknesses or Bob's weaknesses. It was a position description that would describe anybody in that role. If I get hired to do the role, I'm doing the same job as Mary is doing or as Bob is doing. Now, there will always be in a position description. The bottom item is usually other duties as assigned. So there is some flexibility to shrink the job or increase the size of the job. And oftentimes the position description is more expansive than maybe every single person might perform. For example, in a very small store, you might only have, in a JCPenney store that's very small, you might only have, 4 or 5 sales clerks on the floor at any given time. And so that those individuals might be more involved, say, in loss prevention or security aspects than if you have a store that has a professional, devoted staff who are responsible for, making sure there isn't theft going on in the facility. So, you might have your definition to include everything that any person in that role might perform, but you might say, well, in this particular unit for this particular person, this person isn't going to do all of those particular roles. So a job description can be helpful in establishing what's essential and what's not. And oftentimes they will actually use the term, say, these are the essential functions of the job. So it's clear. Position descriptions can be very helpful if they are well written and if they are very careful about how these issues are approached. They can be very bad for their client if they are written casually or without careful thought or without the input of legal professionals. So it's one of those things that I recommend when I was in practice, that I would say don't do position descriptions unless you're going to do a really good job and have a specialist, a legal specialist, an attorney specialist in this area, review them before they go out and before they become official. So just be aware this isn't something to be approached in a lighthearted way. So an employer does not have to justify the speed of production or quality standards that are necessary for the job. So let's say you require somebody to assemble 10 widgets an hour. The employer, the court is not going to be free to say, well, that should have only been 8. That's not reasonable. No, the employer gets to decide how fast the people need to work. Or let's say the employer says, well, no more than 3% of your widgets can fail to pass inspection. Again, that's a standard that the employer gets to set. But the employer has to consistently apply that standard to everyone. And this is important both from the Title VII and Age Discrimination Employment Act and an ADA perspective. If you are applying it strictly against African Americans, but not against Caucasians, that's a problem, obviously. If you're applying it strictly against people who are disabled, but not strictly against people who are able-bodied, that's a problem, obviously. It's pretty common for employers to reduce these standards, especially speed standards for disabled individuals. It's probably not necessary, but it's probably a good idea. The law, strictly speaking, doesn't require it, but I'm not convinced that there aren't courts out there that would say that a reasonable accommodation could be to reduce the production requirements. This is especially relevant if there are grades that people have in that position. For example, you might have 3 levels of order pickers. We'll call it level 1. And level 1 order pickers only pick 20 items an hour. Level 2 order pickers pick 30 items an hour, and level 3 order pickers pick 40 items an hour. As you increase your productivity, you are paid more. And maybe the expectation is that you'll start out at an order picker 1, and you'll be in that for 3 months, and then you'll go to order picker 2 for 3 months, and you'll go to order picker 3 for the rest of your career. But allowing a disabled person to stay at order picker 1 forever at the lower rate of pay would be a reasonable accommodation. So if you have some kind of system where you graduate people to higher speed rates of productivity or require higher levels of quality as a person progresses and becomes more experienced, then keep in mind the option of keeping the disabled at a lower rate. And again, this is going to turn on what the disability is and whether that makes sense. And again, the employer is free to have a lower level of productivity for disabled individuals within that standard. Otherwise qualified, another definitional term. Again, this is really just the definition of qualified, so not really a new one. Able to perform the essential functions of his or her position. Again, if I can perform the typing and the filing and the dictation, it's okay that I can't do those infrequent relief receptionist role or make the coffee role. An employer can't consider the possibility that an employee will become disabled or unqualified for the position in the future. So let's say I apply for the position and I share that I have a degenerative progressive disease. The employer can't say, oh, well, right now, River can perform these tasks, but in 6 months, maybe she won't be able to perform these tasks. Well, at 6 months is when we need to consider that. The employer can't assume that the disease will progress in a certain way or that I will become symptomatic or whatever the situation is. At that point, there may be some reasonable accommodation that can be offered. We will talk about the level of risk when we get to direct threat, but one of the factors that can affect whether a person is otherwise qualified is whether if he or she does that position, will he or she put others or himself or herself at risk of significant risk of harm? And we'll talk about that when we get to direct threat. So Mary works as a stock clerk at the store. She is maybe going to be promoted to merchandise manager. She reveals that she's going to have some surgery in the, not imminently, but relatively soon. And after the surgery, she is not going to be able to move very much. In her new job, she'll have to be moving around a lot if she were to become this merchandise manager. And so the company is saying, well, gosh, we don't want to promote her. And then she has the surgery and she won't be able to do the work anymore. Well, under these circumstances, the employer can't consider what Mary's limitations might be after the surgery. So the department store will have to go ahead and promote Mary if she's the best candidate. And maybe she's not, but the fact that she's going to have the surgery should not play any role in the analysis. So things that can be impediments to being qualified are lacking the necessary skills, the education, or experience. Now, sometimes disabled individuals lack experience through no fault of their own. They have been discriminated against in the past, and that's why they don't have the experience that they need. It's okay, though, for an employer to say, well, we are only considering people with 2 years of experience You don't have the 2 years, so you're not a candidate. Or alternatively, you only have 2 years of experience, but Bob here has 5 years of experience, and so therefore he's the better candidate. And again, we'll talk about the direct threat when we get to a later section. Let's consider qualification standards. So these are going to be the personal and professional attributes, including skill, experience, education, physical, medical, safety, and other requirements established as requirements which an individual must meet in order to be eligible for the position held or desired. So usually these are going to track with what the job listing might say or what the position description might say. When you're looking at the ad, what does it say the person needs to be able to do? So if I'm applying to be a paralegal in a particular law firm, the law firm can say, we want the individual to have a certification. I don't have the certification yet. And so therefore I would not be considered qualified for the job. I might be able to get another job at another law firm that doesn't require the certification. But it's okay for one law firm to require the certification and another law firm not to require the certification. Now, of course, if one law firm is only requiring it for the purpose of restricting its candidates, maybe it's trying to weed out people of a certain ethnicity or people of a certain disability status, that's an unlawful reason. But if it's a legitimate reason why they want to have this particular credential, they're usually allowed to require that. Again, the requirement has to be job related and consistent with business necessity. So I'll give an extreme example. It would be silly for an employer here to say, well, before we're going to hire you as a paralegal, you have to have a law degree. That doesn't make any sense. Now, there are plenty of people with law degrees who work as paralegals. It's not at all uncommon. In fact, in New York, Wall Street law firms, I would say most paralegals there have law degrees, and certainly a very significant percentage do. Even in Texas, many people who have international law degrees work as paralegals, and also people who are licensed in another state but are either not yet licensed in Texas or are choosing not to become licensed in Texas work as paralegals. So it's not unusual to find somebody with a law license or law degree to be a paralegal, but to require that doesn't seem like it would be consistent with business necessity. Let's consider this example. Possession of a valid driver's license, a qualification not available to many disabled people, such as a blind person, is lawful only if driving is an essential function of the job. So you can't say, well, we just want you to have a driver's license as a means of identification, because we want you to be able to show that when you go to various work sites or whatever. But we don't, maybe you'll have someone drive you. Maybe you'll take an Uber. Maybe you'll take the bus system. It's not necessarily you drive yourself from one location to another. Well, under those circumstances, a person could have another type of identification. For example, a passport, or say some kind of company issued ID, or you can even get a state issued ID that's an alternative to a driver's license. And so the possession of a driver's license could be an impediment to a disabled person being able to fulfill that requirement, and it wouldn't be consistent with business necessity unless driving is a factor. Now, usually I would say that a company could get away with requiring a valid driver's license if the job involves, say, operating a forklift. Because the idea is, even though a forklift probably does not technically require a driver's license, certainly that demonstrates that a person has demonstrated the necessary skills, or at least many of the necessary skills in order to be a successful forklift operator. Okay, so let's go on and talk about essential skills. We've already kind of talked about these, but let's look at the definition. So these are the tasks that are fundamental, meaning not marginal or unnecessary, to fulfill the position objectives. And a good question to ask is, would removing that function fundamentally change the job? So if I'm a secretary and I can't type, would that fundamentally change the job? I think most secretaries spend a lot of their time typing. And so I would say, yes, it would in most cases fundamentally change the job. Is there a secretary out there who doesn't type a lot? Probably there is. And in that case, it may be a non-essential function of the job. Again, this is why there needs to be that individualized analysis. Okay, so when determining the essential function of the job, an employer must not look to the means of performing that function, but to what is supposed to be accomplished. So let's imagine that I'm a secretary and I have severe arthritis. I am no longer able to type, but I could probably use something like drag and dictate whatever it is I'm supposed to be typing into the system, and using verbal commands, edit the document so it's looking exactly the way it ought to look. So the employer might be required to pay for me to have the headset that I would need for drag and dictate, and also the software needed, because that wouldn't cost more than a few $100s most likely. And so that would be a way to accomplish the task, but without requiring that I actually type. So this is a difference between the Americans with Disabilities Act and Title VII, because we didn't talk about essential functions when we were talking about Title VII or the Age Discrimination and Employment Act. So we do have this additional inquiry into essentiality. I don't know if that's a word or not. And it's going to be a very individualized situation. So going back to my example at JCPenney, where we had literally tens of thousands of people in the customer service associate function, that was the title that we had for that job. But in one store, that person might not do any kind of loss prevention function. Well, so in that particular store, loss prevention would not be an essential function. But maybe a store just 10 miles away, a much smaller store, the customer service associates are expected to do loss prevention functions. And so in that store, it could be an essential function. So you can't generalize and say, well, one person, this is an essential function, another person, this isn't, when they happen to have the same title. Similarly, let's say I'm a secretary for Bob. Bob routinely wants me to take dictation for him. And so I'm going in there taking dictation. Maybe I'm using shorthand, maybe I'm recording him and then typing it up through a mechanism. Susan has a secretary too. Susan doesn't use dictation. She's not interested in that. So Susan's secretary, it would not be an essential function of her job, let's assume she's a woman, to be able to take dictation. But it would be an essential function of my job as Bob's secretary to take dictation. Attendance is considered a business necessity in most cases. There are some situations where there's a little bit of leeway here. But let's imagine that I happen to have a condition in which I need to be absent from work pretty routinely, and it's not something that I can necessarily plan. I happen to have a spell of my condition, whatever that, a bout of my condition, whatever that might be. And let's say it's a job that I cannot do from home. Well, if it's something that has a time-sensitive element to it, for example, let's say I'm a receptionist, and if I'm not there, there's nobody to greet people who come to the facility. And it's a small enough facility that there isn't another person who can pop in and cover the receptionist function. So under those circumstances, it would be a business necessity that I have regular attendance. But let's imagine I have a job responsibility that I can do from home. Let's say I'm a typist and I happen to have access to whatever the system is from my home. And even when I'm having one of these bouts, I can still be productive and do my work. Or maybe I can't be productive, but the work I'm doing isn't on a short time frame. I'm typing up manuscripts. And so, it doesn't matter whether I complete it on Monday or Tuesday. What's important is that, I'm making progress on completing it. In that situation, it's possible that regular attendance is not necessarily a business necessity. So that's a difference. So example, word processing, filing and answering phones are essential functions of many clerical jobs, but getting coffee for others or lifting boxes of copy or paper probably are not essential functions. They are marginal functions. They can be removed from the disabled person's workload. They do not have to be reasonably accommodated. And again, you can only look at the essential functions in deciding whether the person can perform the job or not. Because if it's a non-essential function, then you remove that function from that person's job list and you evaluate them just with respect to the essential functions. So here's some additional ways of looking at the essential function. Does the position exist to perform this function? When somebody was thinking back before this position existed, we need one more person here. Why did they think that? Did they think that we need one more person here to be the third relief receptionist? Probably not. We need one person here to get coffee twice a week. Probably not. Probably when somebody was thinking about my position as Bob's secretary, they were thinking, or Bob was thinking, I need somebody to type up this stuff. That was probably where his focus was. And so does the position exist to perform this function? And of course, it can be more than one function. This also can be how many other people can perform this function. You know, in a large office, there may be lots of people that can perform the relief receptionist function. But let's say this particular office, even though the employer generally has 15 or more workers, in this particular office, there's just 3 people. Then it might be much more reasonable to say, say that the main receptionist, the secretary, and the manager. It wouldn't make sense for the manager to be the relief receptionist in most cases. And the receptionist does need to take breaks and does need to have lunch and things like that. So it could be that the secretary as a relief receptionist, when there are relatively few other people who could take on this role, could be an essential function of the job. Also, again, if the function is highly specialized, I gave you the example of a soldier who had this very specialized skill set. He would have to perform this very safety-focused task infrequently, but that was why he was there. And no other people were necessarily on duty at that particular time who could as well perform this task. So the more specialized it is, the more important it is that, or the more likely it is to be held to be an essential function. And again, we're going to be looking to job descriptions for that. The way the employer emphasizes that particular role in conversations with the employee, things along those lines. Again, but an employer can't be tricky and put stuff in the position description and act like it's an essential function if it's not. I mean, there is some pushback potentially with the employer. So if you are reviewing position descriptions and you see they've thrown in everything, I mean, it looks like this job is basically to do brain surgery and also to wash the dishes and also to do that. And it's just, way beyond what would be reasonable for any one person to do. You ought to pause and say, is this really, what percentage of the time is Bob, performing brain surgery? What percentage of the time is he washing dishes? And if it's a very small percentage, especially if it's not highly specialized, probably you ought to not consider that an essential function for the position description. Let's look at direct threat. I've kind of given you some teasers about this, and let's dive into the definition here. So again, another term for Quizlet. A person who poses a direct threat to his or her own safety or health, or to the health and safety of others, is not qualified. So this person does not meet the definition of otherwise qualified. So direct threat cancels qualification unless the threat can be eliminated by a reasonable accommodation. So imagine that we have an epileptic employee, and let's assume this epileptic employee does not have advance notice when he or she is going to have a seizure. And so under those circumstances, it could happen really at any time. If he or she has to climb ladders to perform his or her task, you can see the danger to himself or herself, because this person may fall off the ladder if the seizure is happening. But it could also be a danger to other people, because people falling off ladders while you're walking by is dangerous to you. And perhaps the epileptic person falling could cause other things to fall down and hurt other people. So under those circumstances, yes, the epileptic person does pose a direct threat to his own safety or her own safety, as well as to the safety of others. Now, there might be ways of eliminating that by some kind of reasonable accommodation. Perhaps having somebody spotting the person on the ladder. Let's say this isn't a common, the person isn't on the ladder, all the time. So maybe having someone spot, maybe having some kind of safety harness on the person. Again, if this is a warehouse situation, they may be able to have some kind of safety harness that would be able to catch the person if he or she lost grip of the ladder. So you'd have to kind of brainstorm to see, is there a way of eliminating it, or perhaps eliminating the need for the ladder entirely by whatever this worker is climbing the ladder to get at, maybe putting it at a lower level so there's no need to climb the ladder to begin with. The employer can't use direct threat as kind of a, well, maybe this might happen, we're just not sure and we just don't want to take any risks. It has to be a reasonable medical judgment based upon an individualized assessment. So let's imagine that this person with epilepsy hasn't had a seizure in 3 years because of the new medication he or she is on. That seems like probably there isn't much of a direct threat. Or let's say this epileptic person is aware, usually has at least 3 minutes notice before an epileptic seizure happens. Well, assuming this isn't a super tall ladder, he or she is probably going to be able to get to the bottom of the ladder before the seizure happens. And so those would be ways that you still perhaps could allow that person to use the ladder even though the person has epilepsy. So again, it's going to turn on the particular aspects of this person's condition. So sometimes employers are quick to see a connection. For example, a food handler with hepatitis. This is especially true in the food handling industry. There are very specific rules that exist as to what people who handle food, what illnesses and that they can have or can't have. It's usually a best practice to follow those rules and not to require additional testing or additional requirements than what the law already provides. And again, the direct threat doesn't have to be to the employee himself or herself. It could be to customers, it could be to vendors, it could be to coworkers, or all of these categories. So again, the things to think about when you're thinking about direct threat is, what is the nature of the risk? What could happen? What's the worst case scenario? How long is the risk going to last? Again, if this is something that is going to be ongoing for a long period of time, but maybe this is just the person, say, on chemotherapy and they get lightheaded sometimes. Well, why don't we just say, don't climb on the ladder during this period of time that you're taking chemotherapy? So there may be an ability to be flexible during that particular risk time. The severity of the risk. What's going to happen if the person falls off the ladder? I mean, if it's a step stool, probably nothing too bad. I mean, worst case scenario, maybe a broken arm, if something, if a person turns the wrong way, that's not lethal. But if it's a ladder that's, say 10 feet tall, that could be, potentially life-threatening. Issues can arise sometimes with these types of conditions. Diabetes, if a person has a situation where their blood sugar drops too low, it can be a fatal situation. Epilepsy, again, a fall in a dangerous place, let's say a place that has heating units like in a kitchen, or knives like in a kitchen, or where people are climbing at a higher level. Hepatitis C can be, if there's any kind of blood exposure, can cause problems there. PTSD, sometimes people with this condition, and not frequently, but occasionally people can react unexpectedly in a violent way when they are having a kind of a flashback moment. And then again, if kind of like hepatitis C, if there is blood exposure, there can be an issue. Most cases, people who have, in the vast majority of cases, people who have HIV and hepatitis C can work pretty much anywhere safely. And so it's rare that a court is going to say that somebody with HIV poses a direct threat. In fact, probably of these categories, probably epilepsy is the only one that I've seen direct threat cases really stick for. So this case, you don't need to know the name of it. Does the ADA permit discrimination against those individuals whose health would be threatened by the conditions of the workplace? I've been saying up to this point that a person's own health or safety threats to that can satisfy the direct threat exception. And that is true. That the case that reached that decision is this one. I can't pronounce his name, so I'm not going to attempt it. Anyway, he had hepatitis C, and he was going to be exposed to some chemicals that likely would cause his condition to worsen. The employer did not want to hire him into that position because it didn't want to make the man sicker. The man still wanted the job. He was willing to take that risk. The Supreme Court said, nope, threat to self is a permissible grounds for refusing to hire. Now you may say that's awfully paternalistic of the court. It is a little bit, but maybe not so much, because keep in mind, if this person had been hired into this position and his condition had worsened, Chevron very likely would have to pay workers' compensation benefits and also health insurance benefits, assuming this was a benefit eligible position. And so it wasn't just this individual accepting a risk that he wanted to bear, but in some sense, the employer would have also been bearing that risk. Again, you don't need to know the name of this case. You do need to know this idea, though, that threat to oneself can be a direct threat situation that would mean the person was not otherwise qualified. Let's consider reasonable accommodation. Again, here's the definition. An accommodation to the individual's disability that does not place an undue burden or hardship on the employer. So this definition is a little circular. You need to know what undue burden or undue hardship is for this to make sense. And we'll talk more about that as we go forward. So it is a little circular here. Many times this involves simply removing barriers that exist that they weren't necessarily intentional barriers, but they existed because they hadn't previously had a disabled person there. So imagine that I'm a secretary and I am a wheelchair user. Files may need to be moved to a lower location. I may need a bigger office so that I can maneuver around. I may need more filing cabinets because they're going to be lower. So the physical plant where I'm working may need to be different to remove those obstacles. There may need to be ramps in places where there were maybe steps or things along those lines. Those would all be reasonable accommodations. It may involve equipment, it may involve training. And while, of course, the person has to be otherwise qualified, so you don't have to train them how to do their job, but there may need to be, say, software training. So, for example, going back to the example, let's say I'm a secretary. Maybe I've worked there for a lot of years, and my arthritis has just recently gotten very bad in my hands, so I'm no longer able to type. So the company has decided to use drag and dictate software. Well, I'm going to need to be trained on it. And so that may involve some time and some expense to get me to that point. Again, the duty to reasonably accommodate doesn't apply just to disability. It also applies to religion, as we learned about in the Title VII section of the course. Of course, what we mean by reasonable accommodation is pretty different between these two statutes. The language actually in the two statutes is identical, but what they mean is pretty significantly different. An employer has to do a lot more for a disabled person than for somebody who needs a religious accommodation. We learned under the drawing a blank on the airline name. Okay, but you know, the de minimis case, where the worker worked as, I think, as a machinist for the airline, and TWA case. And the U.S. Supreme Court said that all that the employer had to do was incur no more than a de minimis expense, and a de minimis meaning essentially trivial expense. Well, under the Americans with Disabilities Act, the threshold for reasonable accommodation is significantly more than de minimis. Yeah, there are times where employers have to spend thousands of dollars, even possibly tens of thousands of dollars. And so the de minimis standard is not in play for disability reasonable accommodation. So Mary is a trained medical secretary. She suffers from a condition that causes her to have periodic severe headaches that can last a little while or a long time. There's no cure, and the medication she takes makes her drowsy. Her request to work on a flex time basis is denied because it'd be impossible to prepare a schedule for a department without being sure she was able to work. And again, she doesn't know when she's going to have one of these debilitating headaches. So probably the hospital is not going to be liable under the ADA because Mary's erratic, unscheduled would be the better word here. Unscheduled absences are not subject to a reasonable accommodation. So this is how it plays out in this case because Mary does a unique job. But let's say there were, in addition to Mary, Bob, Susan, and Larry also are working as medical secretaries. And so it really would be fine if Mary were gone because Bob and Susan and Larry could pick up the slack while Mary was out and do whatever emergency projects came up. So don't assume because a person does have these unscheduled absences regularly that necessarily means they can't be reasonably accommodated. So you just have to work with the situation. And again, if it's a person, the only person doing the job, that's something that can be accommodated. But if there's others, sometimes you can still work with the person who has an unreliable ability to be at work. Let's look at what reasonable accommodation does not mean. So I'm going to show you several examples here. We don't have to create a new job, just the one they have, right? And so you don't have to create a new job. Now, sometimes what happens is that you and the employee decide that this particular job doesn't make sense for the employee anymore, and that you happen to have another job. And the employee says, yeah, that makes sense. And you think it makes sense. So you certainly can move a person to another job, or you can create a job if you want to, but there isn't the necessity that you create a new job. And employers are not required to accommodate employees by lowering a production standard that applies to all employees. Again, the key word here is all employees. We have to be consistent. So if there's a training level of productivity, or there is at least initial flexibility with new workers, you ought to apply that same standard to the disabled even beyond their new worker period of time. And again, employers are not required to accommodate by lowering a production standard, but they certainly are permitted to do so. And that can make a lot of sense to do that. Firing somebody who can't make a production standard, but they still are able to be pretty darn productive is probably not the smartest strategy for that employer to do. But it's probably lawful. You don't need to reduce the workload of the disabled person and assign, unless of course we're talking about the non-essential functions. Those you do need to move if the disabled person cannot perform those functions. You do want to keep in mind that the non-disabled employee isn't going to have any claim. So the non-disabled, because we don't have any kind of reverse discrimination claim under the Americans with Disabilities Act. So let's say we happen to have two people who do a job, Bob and Susan. Bob is disabled. Currently, before Bob, let's say Bob's been in this position for a long time. When he was initially put in the position, he was able-bodied. As a result of and prior to his disability, he was doing 50% of the work and Susan was doing 50% of the work. Bob is now disabled. The employer shifts 20% of Bob's work to Susan. So now Susan is doing 60%, Bob is doing 40%. Susan has no claim under the law. Susan is a non-disabled person, so she can't say there's some kind of reverse discrimination. But the employer is not required to reduce Bob's workload, except the employer is required to remove the non-essential functions Bob can't perform. And maybe that's 10%, but it's not necessary. The 20% that is reducing from Bob, if those were essential functions, the employer isn't required to do so. Can the employer do that? Yes. Is that a smart plan? Probably not usually. Again, reducing the non-essential functions, that's necessary, but reducing the overall workload, not necessary. It is not necessary that the disabled worker have more rights to his or her job than provided to a non-disabled employee. So let's say there's layoffs going around in the office. There's a need to reduce the workforce by 20%. And let's say the decision that the firm has made is to lay people off based upon their date of hire. Bob, the disabled person, was hired more recently than Susan. It's perfectly fine to lay Bob off under those circumstances. Of course, it would be unlawful if the employer decided to use date of hire simply to get rid of Bob. And so you have to make sure that the motivation is not some type of disability discrimination. But if the process that the employer follows is consistent and a reasonable one, and it just happens to impact the disabled person, that's going to be a defendable situation. And it's not necessary for an employer to provide things like personal use items like wheelchairs, prosthetic limbs, eyeglasses, hearing aids. If there are specialized things the person needs the job, though, specialized equipment, that is appropriate. So for example, a ladder with handrails that the disabled person could use, for example. Obviously, people don't walk around carrying their ladder with them throughout their day, so that would not be a personal use item. An extra large screen on their computer so they could blow up the font so they could see things more clearly. Again, not a personal use item. If the employer has very narrow aisles within the facility and it's decided not to change those aisles, then it could get the employee a smaller wheelchair so that the employee could have access to various parts. So generally the employer would not be required to provide the employee with a wheelchair, but if there were some particular obstacles at the employer's place of employment, an alternative wheelchair could be a reasonable accommodation under those circumstances. Okay, let's consider undue hardship, our last topic for this lecture. And here's our definition. An undue hardship exists, so again, this is good for Quizlet, if the action would involve significant difficulty or expense in relation to the size of the firm and its resources. So again, here's the standard. This is the reasonable accommodation / undue hardship standard. Under the Americans with Disabilities Act, employers must make reasonable accommodations unless doing so would provide an undue hardship on the business. So this will say that this is the level for this particular business. So the employer has to do whatever is necessary up until that point. This is again going to be a very individualized analysis. For a bigger company, the line might be here. For a smaller company, the line might be here. For a more profitable company, the line might be here. For a company that's just on the brink of bankruptcy, the line might be here. So there are lots of factors in this analysis. Again, most employers err on the side of being a little bit more aggressive. If they don't want to be in the gray area, they don't want to be close to the line, so they're going to do more. They're going to do, or before they say no, they're going to be persuaded that there's really no way that the law could require that they do that. Because keep in mind, a lawsuit is going to cost probably $100,000. So why would you decline to spend $2,000 on software when, if this person files a lawsuit, you're going to have to pay $100,000 or more than $100,000 to the law firm to represent you? So it's pretty strong motivation to err on the side of assuming it's not an undue hardship. If you are thinking maybe that's an undue hardship, you want to get numbers together. You want to be able to tell the story about what makes it an undue hardship. So you're going to want to document the costs and what problems might arise by doing that. So for example, if Bob is on the assembly line and Bob says, well, I need 5 more seconds to do this particular task. That may seem like, well, why can't you give Bob 5 more seconds to do that particular task? But if you can show, well, that would slow down all the other points on that line, it would affect all the other workers who are doing other tasks on the assembly line. So you'd want to document that, tell that story before you have a definite decision. And so then if this does get into litigation, you can have, number one, you know that you're going to have a good story to tell. And number two, you're going to be able to show that before you said no, you thought carefully about it. There are grants and tax breaks that are available to help employers with these types of issues. So an employer that's struggling financially and may think, oh, I can only do this much. Well, if they knew that they were going to get a tax break, maybe they could do this much or this much. And so it's important for the employer to consider the full bundle of things that are available to it before it makes the decision, because you can count on when it's in court, definitely the plaintiff's attorney will have researched and said, it wouldn't really have cost the employer that much because there's this grant that it could have applied for, or there's this discount or this tax break. And so really, instead of it being $2,000, it really would have only been $1,200 or something along those lines. So again, the things that might count as hardship factors would be financial difficulty. Would it disrupt the workplace? Would it cause a lot of problems in terms of the processes that exist in this particular place? And would it fundamentally alter the nature of the business? So for example, imagine that I'm a customer service associate at a JCPenney store, and I'm saying, well, if and let's say that my problem is that I can't reach across the counter to get the merchandise from the customers. And so I might say, well, if the customer would just go around to enter into my little kind of cash register area and give it to me that way, then I would be able to complete the transaction. And so, that seems like a relatively small change. It's not going to cost any money, but customers are going to be kind of taken aback by that. There could be some loss prevention concerns with customers back in that area where there may be cash or credit card information. And it would be perhaps, arguably, a fundamental alteration of the nature or operation of business. Because again, customers have a certain expectation about how they're going to check out in a department store, and it doesn't involve them going behind the desk. So there might be some customer service implications. Customers might be uncomfortable with that. That's an example of something that might apply that could become an undue hardship, even though it wouldn't cost money. If something is being held to be an undue hardship because of financial difficulty, the employee should be given the option of paying for that cost, whatever it might be, out of his or her own pocket. So again, if there's some software that I need, then the drag and dictate example, and let's say all of that software is going to cost $700. Well, if the employer says, we can't pay for it, so we're firing you, if I want to pay for it, I should be allowed to pay that $700. Again, we said before, there needs to be a fact-intensive, individualized evaluation. It's also important that employers use creativity, because a lot of times there doesn't need to be something fancy. For example, let's say an employee needs can't read the screen on their computer. It's just a matter of increasing the font. That is usually free. Now, they may need a bigger monitor, but maybe you could take a bigger monitor from another worker who doesn't have a disability and give them the smaller monitor. You may already have one available, and so you might be able to, by just moving some things around, solve the problem and not even incur an expense. There are lots of resources out there to show folks how they can accommodate these various issues. There's lots of creative approaches. The JAN is a very common way to look. Let me just show you some resources there. This is that askjan.org website. And again, you just click on accommodation search, and you can, let's say somebody has a headache issue. You can go in here and read about various conditions that might be affected by that and various accommodations that other people have used to work through those issues. And again, most of the time the expense is very small, and there's lots of really innovative ideas out there. So, and again, the employer would want to document that they looked on JAN and put that in its notes, and have also talked about why. Let's say the employer is saying no to this particular employee. The employer should, see that, or should document, well, we didn't do this because, Jan said this was a possibility, but it didn't work for us because XYZ. And so be sure that you can tell that story about why you didn't take the leads that the Jan said were available to you. We're going to talk more about the interactive process for the reasonable accommodation. It's very similar to the one we use for religious accommodation, but we'll talk about that in another lecture. So let's talk about this individualized, or this scenario. So Bob is a sales rep. He travels to stores to meet their managers and view their inventory. Unfortunately, Bob's left hand was severely impaired and only his right hand is functional. Bob wants a one-hand driving system to be installed. It's going to cost about $40,000. This is more than the company can afford. Arctic Fox should convey to Bob that it cannot make the requested accommodation due to undue hardship, but Arctic Fox should see if there might be another open position for which Bob would be qualified. And in addition, it should give Bob the option of paying for it himself. There may also be some other technology that doesn't cost as much that, again, looking on JAN might make sense to consider. So it's important that even if Arctic Fox ultimately says no to Bob, that it can document and show its efforts. And those should ideally be communicated to Bob, because number one, that may make Bob feel better about the decision, and also it may make Bob less likely to sue under those circumstances. Here's another scenario. So Bob is a critical care nurse at a private hospital. He tests positive for HIV. Whenever an employee whose job requires him or her to have direct contact with patients' blood tests positive for a bloodborne disease, the hospital shifts him to a desk job with no change in his salary. But Bob refuses to this arrangement. He wants to continue in his role as care provider in the hospital. He requests that the hospital reasonably accommodate him by hiring a part-time nurse to follow him on his shift and to keep check on him to make sure he is not, when he's caring for the patients, not doing anything that could expose the patients to his blood. The hospital denies his request and fires Bob because of his unwillingness to move to the desk job. In the vast majority of positions, HIV positivity or hepatitis C positivity is nothing that has to be even reasonably accommodated. And if there is something, it can easily be reasonably accommodated. But because this involves critical care in a hospital where things can change rapidly, there may need to be surgical procedures done, there may need to be blood drawn, again with sharp needles. things along those lines. Because of the very specialized nature of Bob's career, Bob's request can be lawfully denied because it would represent an undue hardship for the hospital, because it would be exposed, there would be a direct threat to patients and possibly to the doctors and nurses who work with him. Because again, if Bob is called to assist with a procedure, Bob could get nicked by a scalpel, Bob could get punctured by a needle, and then his blood could be exposed to, or patients could be exposed to Bob's blood. So for the very narrow job that Bob has, that he would not be a good candidate for the job involving patient care. And therefore, there is no reasonable accommodation because of the direct, actually he's not otherwise qualified because of the direct threat he poses. So now we have completed talking about both the introduction, the prima facie framework that the plaintiff must prove for ADA cases, and we've talked about some key terms: disability, major life activity, qualification, essential functions, direct threat, reasonable accommodation, and undue hardship. In our next lecture, we will talk about the reasonable accommodation process. I hope that this presentation has been helpful. If you have any questions, please feel free to stop by my office hours. I'll be glad to answer them. Take care. Have a wonderful day.